Hi there, this is week 4 of Knowledge November, and we've been talking about this idea of affirmation. And that naturally will lead you to say, well, how long does the employee have to, how long do they get to make their decision about are they staying, are they going, as a reaction to whatever it is they say the employer has done wrong, and how quickly do they need to react? And the case law on this is really mixed. I think the only clear guidance that I can give you is that if somebody has just gone on the sick, because they'll be in receipt of sick pay, they will need to do something else to dislodge the presumption that they are affirming the contract, and agreeing that the relationship continues. So sickness is quite a problem for an employee. They would need to be doing something like raising a grievance, making it clear that they are not happy, working under protest, reacting to the breach, alleging that you are breaching the contract, etc., to really get a judge to sway. In terms of other cases, I think it's not actually a question of time. I can't say to you there's a magic number. It's more about why somebody's delayed, and again, their conduct during that period of delay. I must admit, I've always erred on the side of feeling that an employee needs to act quite quickly when there's been a fundamental breach, and that any delay really could risk affirmation, and I think that's right. But when you look at the cases on this, there are some really quite long periods of time where the judges have said, no, that isn't an affirmation. That person was just getting their ducks in line. It was reasonable for them to be understanding, what was going on, getting legal advice, finding out, what their rights were. It's a big decision, you're going to lose your income, all of those sorts of things. So quite generous decisions to the employee. And, just to give you some examples, I'm talking about cases of delay of, a month, 4 weeks, 6 weeks, even 8 weeks. But there are cases going the other way as well, and supporting the employer. So it does really come down to the why everything was happening at the particular time. There was one example where the judges were quite generous to some employees who'd been abused, really, in their role in a restaurant. They were migrant workers, so they were vulnerable people, and things had been okay and tolerated by them in terms of the sex discrimination that they'd been subjected to by the owner of the business for quite a long time. They tolerated it whilst there was an assistant manager who kind of looked after them a little bit, but when she left, then they decided to bring a complaint, and the judges likened in that case those ladies to a battered wife who puts up with violence. Putting up with it doesn't make it a welcome thing, and were prepared to be really quite generous with how long they took to then bring their complaints. So it does always come back to the factual position. If I was going to try and give you a time frame, because I know that's what you're going to want, I would be saying a delay of 3 months, I would say, is too long. There's certainly be cases where people who've delayed for sort of 7 months, yes, definitely too long. Less than 3 months, we're into probably territory where the judge might be lenient, but you're always going to have that argument in your pocket that they have affirmed the contract. And by looking at the things that have gone on around it, we may well be able to defend a claim on that basis.